Welcome everyone to this webinar today, addressing issues that arise in family court cases involving immigrant survivors and children, learning from judges. And we're going to turn it over to open to Judge Julie Breslow.
Good afternoon, everybody. I'm glad you're able to join us. Just so a little bit about who I am. I'm a magistrate judge in D.C. Superior Court. I've been assigned to the family court for almost 18 years now. Most of the time I have been doing child abuse and neglect cases, but also some domestic relations and custody cases. And in 2019, I was assigned to handle all the domestic relation branch cases where someone is seeking custody of a minor and also seeking to have a special immigrant juvenile order granted by the court so that the child could then seek special immigrant juvenile status in immigration court. So I've been doing that since the beginning of 2019. I granted about 60 SIJS motions in 2019. Our numbers are down for 2020 because we had a couple of months there when we weren't hearing the SIJS cases. But despite the pandemic and the court's physical closure, we are continuing to hear SIJS cases. I'm looking forward to hearing your questions and hoping that you'll get some good information today.
Hi, everybody. I'm Judge Rosemary Collins, recently retired after serving almost 30 years on the bench here in Northern Illinois. While I served on the bench, I was the presiding judge of the Family Division, and I was the presiding judge of our Domestic Violence Division, in which we co-located both criminal and civil courts that all dealt with the issues of family violence. I was also the certifier in our area for petitions, VAWA petitions, so I'm really excited about being here with you today.
Hi, my name is Leslie Orloff. I direct the National Immigrant Women's Advocacy Project at American University Washington College of Law, and I'm very happy to be here today as well. I have been running a project for the last about 7 years, training judges and across the country on issues that arise in family court in cases involving immigrant crime victims and immigrant kids. And a lot of that information we're going to be talking with you about today. We also, at NUAP, run a family law community of practice for family lawyers across the country who are working with immigrant survivors that you are, if you're interested, you're welcome to join as well, and we can send you information. Just as we get started, I want to say that this event has been approved for 1.5 CLE credits for Pennsylvania and Virginia, and American University, our home university, is the accredited provider for both jurisdictions, and this is the information regarding the CLE credits. Judge Breslow? I think you might be on mute.
I'm not on mute. Can you hear me? Leslie, can you hear me?
Yes.
Oh, good. Okay. Yes. So as far as learning objectives today, one of the things I want to make sure that you learn to do is to spot some issues. So whenever you don't have to become an expert, but you do need to spot the issues when you have immigration issues. And whenever you have a client who's eligible for some form of immigration relief, we want you to have at least an idea of maybe what that client may be eligible for. We'll teach you a little bit about each of the different forms of relief that are available. And again, just hope that you learn enough to spot the issues and hopefully can help your clients seek immigration relief.
So as we get started, we're going to talk very briefly about some of the key dynamics regarding immigrant survivors. I know many of you do a lot of work with domestic violence survivors and with child abuse victims, but we're going to focus on some of the particular issues around immigrant victims. And one of the things we learned early on, and this first part was data we actually took to Congress when we were working on creating the VAWA self-petition in 1993, that when a perpetrator, when you have a marriage between a U.S. citizen and a lawful permanent or a lawful permanent resident and a foreign-born spouse, when the spouse, the U.S. citizen or lawful permanent resident spouse is an abuser, the chances that he or she will actually file immigration papers for their foreign-born victim spouse is very low. Less than a third actually file cases, and those that do file delay for a mean period of almost 4 years. We see immigration-related abuse occurring in about 65% of the cases where U.S. citizens and lawful permanent residents are married with foreign-born women. And what we also see is that when you just look at citizen spouses, the abuse rate when citizen spouses are married to foreign-born spouses rises to almost 60%. We also see that there's sexual assault, the likelihood that immigrant girls will have experienced sexual assault by the time they get to high school is twice as likely than their non-immigrant peers, than U.S.-born girls. So there's a lot. You may see sexual assault, and it's something you might want to be looking for immigrant girls who, for girls among the population of girls that you work with who came as immigrants, as children. The other thing that's important to remember about immigration-related abuse is that it co-occurs with physical and sexual abuse. When we first did this research, I really believed that we would see as much immigration-related abuse threatening to turn her into immigration or threatening to file or withhold papers occurring as often in emotional abuse cases as well as physical and sexual abuse cases, but that is not the case. It actually predicts either, it's like that cut telephone cord in, when we used to train on domestic violence things, when we used to have corded phones, that was a sign that there was domestic violence occurring in the relationship. Same thing with immigration-related abuse. It is not, it coexists or predicts escalation towards physical and sexual abuse. The other thing that's important to note is that perpetrators of abuse against immigrant victims, when you look at victims who actually begin to file immigration cases, VAWA self-petitions and U visas in particular, one of the things you see is that perpetrators are actively involved in trying to get the victims removed while the case is pending. So perpetrators have a stake in and will try to use the system against the victim, and can be very effective, which is why filing immigration cases as soon as possible can offer some protection for immigrant victims. Judge Collins? Oops, you're muted.
This is magic. And what it is we're going to go through a brief overview of the different types of immigrant relief and protections for immigrant victims here, but we can't go through each one in as much depth as we'd like to. So this is a great resource. When you need more information, say about a T visa, you go back to this shield, and if you click on T visas, then you'll be able to get more in-depth information about T visas. So if you have a client in, or if you have a case in front of you and you want to know, well, is this a T visa? Is it a U visa? What is it? As an SIJS, go back to this slide and you can, really quickly get a brief overview of each kind of immigration relief. So it's a very valuable slide to have as a resource. For VAWA self-petitioning, VAWA allows battered immigrants to petition for legal status without relying on their abusive U.S. citizen spouse or licensed or permanent residence, legal licensed permanent resident spouse. I keep saying licensed, but it's legal permanent residence. So if you are a battered immigrant and you're subjected to either battery or extreme cruelty, if you are married to a U.S. citizen or a legal permanent resident, and you've lived with them, and as long as you meet these other requirements, then you can petition for immigration relief on your own. You don't need to have your spouse petition for you. You have to have good moral character. It has to be a good faith marriage, but you can, in fact, go ahead and petition yourself for legal immigration relief. One of the things that people wonder, what does extreme cruelty mean? And of course, extreme cruelty means a lot of things, but it doesn't just mean battering. There are other ways that you can qualify under this, such as emotional abuse, immigration abuse, which Leslie just talked about. That's very common, and that is a form of extreme cruelty. Social isolation, taking away their papers so they can't go out, not letting them visit other people, harming their pets. We see that a lot in our system, unfortunately. So these are all different things that may qualify somebody for VAWA self-petitioning, even if there's no actual physical battery that has taken place.
So special immigrant juvenile status is a form of relief for unmarried children who are seeking immigration relief. They have to be under the age of majority under state law. In D.C., that's 18. And the state court, not the immigration court, but the state court has to be able to make a finding of abuse, abandonment, or neglect or dependency by at least one parent. It does not need to be both parents. And it's a state court decision, and we'll talk about this a little bit more in depth later, but I think the thing that I want you to know is if you have a case in D.C. with a child under 18 and there are immigration issues, you definitely are going to want to think about, is this child eligible for SIJS status?
Judge Collins? Is she there? We're not hearing you.
Maybe she's on mute.
Can't tell.
Oh, can you hear me?
Yes. Now we can.
Okay. Well, I don't know what happened there. I'm unmuted. So a crime victim may be eligible for a U visa if they are a victim of qualifying criminal activity. And the reason that Congress wanted to make sure we had this is because we want crime victims to be willing to work with the police, not only for their own protection, but the protection of all the rest of us. So we want to make sure that we have a way for crime victims to not be afraid to work with the police if they are a victim. So they have to be a victim of qualifying criminal activity. They have to be either have been or being or likely to be helpful in the detection, investigation, prosecution, conviction, or sentencing, which means if they call the police and say, I've been a victim of a crime, that's helpful. They have to have suffered substantial physical or mental abuse as a result of the victimization, and they have to possess information about the crime. They don't have to be able to identify their attacker, though. They can simply say, if they were a victim of battery, say they got hit from behind, they can say they were hit from behind, and that's information about the crime. And the crime has to have occurred in the U.S. or violated U.S. law. So this is what a U visa overview is for a victim of crime. The next one we're going to talk about is T visa. And a T visa is primarily it's for trafficking victims, not only sex trafficking, but also labor trafficking. It's a type of visa that allows victims of human trafficking to remain and work in the United States. So a lot of these are sex trafficking, but there's also labor trafficking where people are brought into this country as housekeepers or as potential spouses, and they're actually used for labor trafficking purposes. Sometimes they're promised marriage, but when they get here, they're just put to work in a firm or the family business, and they don't have any freedom of their own. The victim must be physically present in the U.S. on account of the trafficking. They don't have to have known that they were coming over here to be a victim of trafficking. They could think they're coming over here to be a model, and then when they get over here, they're victimized as in child pornography or any other kind of pornography. They must comply with reasonable requests for helpfulness in investigating or prosecuting trafficking. So they have to help, and they have to show that their removal from the United States would cause extreme hardship. And that extreme hardship could be that they can't get the medical or psychological protections and assistance that they can get in this country, that if they were a victim of sex trafficking here, if they went home to their home country, they'd be stigmatized, they might not be able to marry, they might be a victim of physical abuse by others in the community who feel that somehow they are damaged because they were sexually abused. So if they don't have protection in the home country, that can constitute extreme hardship.
Also important about that is that human trafficking, there are cases in which you could have human trafficking occurring within a marriage, for example, as Judge Collins mentioned, but also it's important that it's not about how somebody enters the country. So somebody could have entered the country totally unrelated to their trafficker and end up in a trafficking situation where their movement is now being controlled. What's important to understand in family court cases is that the abuse, if any of these kinds of abuse is happening on the left, so it could be domestic violence or child abuse, child abandonment and neglect, there are multiple forms of immigration relief that a victim may qualify for. So domestic violence could qualify for VAWA, it could qualify for a U visa. Child abuse could qualify for U visa or SIJS, but this gives you a chart where you can see that many of the victims of domestic violence, sexual assault, stalking, dating violence, trafficking, child abuse will qualify, whether the victim knows it or not, for some form of immigration relief. And that the filing for immigration relief has benefits for survivors. There's protections from deportation that happen fairly quickly after a victim files under the Violence Against Women Act confidentiality laws. As soon as a case is filed, it's logged into a special computer system at the Department of Homeland Security that informs immigration enforcement officials that this person is a victim and that they shouldn't be enforcing immigration laws against them. And people can include, you can include family members in their application, and it helps it creates a path to legal immigration status, a path to work authorization, a federally recognized ID, and as we'll be talking about in more detail shortly, more access to public benefits.
All right, so we're going to do a little case scenario here. I'll just read it. Clara met Eduardo, a lawful permanent resident, when he came back to his hometown to visit his family in El Salvador. Eduardo started dating Clara, who was raising her 9-year-old son, Miguel. After Clara became pregnant and gave birth to a baby girl, Lupe, Eduardo decided to bring Clara, Miguel, and Lupe to the U.S. to live with him. When they arrived in the U.S., Eduardo took Clara, Miguel, and Lupe's passports and became physically and sexually abusive of Clara and abusive of Miguel, who tried to protect his mother from Eduardo's abuse. Eduardo also physically beat Lupe when he said she misbehaved. Within a year of following their arrival in the U.S., Eduardo forced both Clara and Miguel to work for his family's business and never paid them for their labor. One night, when Miguel was 13 and Lupe was 5, Eduardo's rage led to severe beatings with a belt from Miguel and Lupe. When Clara intervened to protect the children, Eduardo strangled her until she passed out. The neighbors called the police for help. Clara talked to the police when they arrived. The police arrested Eduardo for attempted murder and child abuse, took Clara to the hospital, and placed the children in the care of the state. So the question really is, what immigration relief would Clara qualify for? And we've got a couple of choices here.
Okay, and do we have a poll? Okay. So if people could fill in the poll with your votes of what Clara would qualify for. We have a couple people joining. Is it visible to everyone? Okay, so 2 people have said all of the above. So the answer is, that's true. It is all of the above. Okay, good. It's all of the above, and that what happens is Clara qualifies for the U visa because of the, being beaten and passed out and the domestic abuse. She qualifies for a VAWA self-petition as the parent of Lupe. She doesn't qualify for a VAWA self-petition herself because there's no marriage here. She's not married to Eduardo. So as a result, she could only qualify as Lupe's parent. And she qualifies for the T visa because she was forced to work and wasn't paid. Next poll, please.
So what form of immigration relief would Miguel qualify for?
So, can we have the next poll, please? Okay, so you can go on again and vote on what the correct answer is. Is it a VAWA self-petition, a U visa, a T visa, SIJS, or 2 of the above? Okay, so we have people voting. Great. So it looks like most of you are saying 2 of the above. That is correct. Why don't you type in the chat box which 2 you think it is as we close the poll, and I can't see the chat. I gotta remove this. Okay. There we go. So in the chat box, okay. So the answer is, let me walk through them for you. So it's 2 of the above. He can't VAWA self-petition because there's no marriage, so he's not a stepchild. He's eligible for a U visa because of the abuse he suffered. He's eligible for a T visa because of the being forced to work like his mother was. And he's not eligible for SIJS because there's no marriage. If there had been a marriage with a step between Eduardo and Clara, then Miguel would qualify as a stepchild as well for SIJS. Great. Next slide. Back to you, Judge Collins.
I can't tell if anybody can hear me or not. I can no longer hear anything.
We hear you.
Well, apparently people can hear me. So it's important that judges know that we have a very important role in immigration. It's when we make our findings, we should say what the relationship is between the parent and child. We need to say this child is the natural born child of this parent. We need to talk about what happened in your findings. Say this child was a victim of extreme battering or sexual assault or child abuse. We do this because Congress created a role for us, and their role is designed for judges because we are the ones who are supposed to be making the factual decisions. Congress can't go out and make these factual decisions, but we do it every day in our work as a judge. So they crafted particular roles for judges, and that's what we are supposed to do, is make these fact findings and communicate them in a way that they can use in their immigration petitions. And we must make our rulings consistent with VAWA confidentiality.
So I want to ask the judges, why might it be important for judges or family lawyers to know?
It's important for judges to know what kind of relief that immigrant victims and children can qualify for. And Leslie, you want to give us more information about that?
Yes, can you hear me? My mic. Okay. So so to help judges and family lawyers and people working with immigrant victims identify which immigrant victims qualify for which kinds of benefits. One of the things that's important to know is that it varies by state or jurisdiction, and it varies by immigration status. So, and it varies by like when the victim first entered the United States. We're going to be doing a much more detailed webinar that we're going to go into a lot more depth for folks in DC on the benefits available in DC for immigrant survivors. But we have on our website a map. If you go to map.newapp.org, you'll land on this map and you can click on it and it will tell you, for example, for TANF, this is cash assistance, who can get TANF in your jurisdiction. We've summarized those pointers here. Generally speaking, I'm not going to go into a lot of detail. You'll have this as part of the materials, and they're going to send you a chart with all of the citations to this. But in TANF, for example, trafficking victims have the most access. And generally speaking, for any benefits, trafficking victims have the most. U-Visa victims will have the least. VAWA self-petitioners will have more access. For example, as soon as they file the VAWA self-petition, they get access to public and assisted housing. There are different points in time where people, so children of VAWA self-petitioners under the age of 21 qualify for medical assistance. And actually everybody under the age of 21, I believe, qualifies for medical assistance in DC. But for adults, it's a bit more restricted. And these charts, these summarize kind of the benefits access of who qualifies for which benefits in DC. We also have materials in your materials that we're giving you about CARES Act, Recovery Act payments. And many of you could be working with victims who have work authorization and a Social Security number that's work authorized. And those people could cover for care, if they file 2019 taxes, could qualify for Recovery Act payments and unemployment insurance. So there's a lot of information we can provide you and give you tools. We're providing you tools so you can figure out easily which of your clients can qualify for which benefits. Judge Collins?
So for U visas, we know that a victim of qualifying criminal activity is eligible for a U visa when it occurs in the U.S. or violated U.S. law. They possess information about the crime, and they're helpful or have been or are going to be helpful in the detection, investigation, prosecution, conviction, or sentencing, and they've suffered substantial physical or mental abuse as a result of that victimization. So what are qualifying criminal activities? Well, any kind of case that you have before you, say, in an order of protection court is going to be qualifying criminal activity. It can be domestic violence, it can be sexual assault or rape, it can be prostitution, it can be perjury, it can be witness tampering if they tell somebody they better not go testify against me. So there's a lot of crimes that you actually do see in your courts, even in a family case or in an order of protection case, that will be a qualifying criminal activity. And any attempt or solicitation to commit any of these crimes or similar activity is a qualifying criminal activity. So the crime doesn't actually have to be committed. It can be an attempt to commit that crime. So when will judges, which judges would attorneys seek certification from? I don't know if you can type in the chat, but you can seek certification from judges who hear any of these types of cases. I do orders of protection cases, I do criminal cases, I did divorce cases. Any of those kind of cases have evidence that might come before them on qualifying criminal activity. It could be a parentage case. It could be child support. It can be any of those cases that the judge can get information that they can use then for the certification. And in our area, we had a system set in place where the certifications all came to the presiding judge. And so as the presiding judge, I did the certification. So the judges can note the helpfulness from the court cases. For example, if somebody comes in and testifies, if they file for an order of protection, if they call the police when an offense occurs, if they have taken their child to some kind of counseling to help them deal with that. There's all sorts of things that a judge can look at to show what type of helpfulness that parents or a victim can show to meet the prong of helpfulness in our immigration cases. So you need any one of these judges. You don't have to be like we were called circuit judges here. You have magistrate judges there. It can be any of those. It doesn't have to be a particular title. It's just people with designated decision-making authority. And you can make your decision on helpfulness based upon what you see in the record. So I didn't actually hear all the cases that I was the certifier for, but I could look at the court file. I could see what was in there. They often would attach police reports, so I could see what happened at the scene. So you can look at all the information that's presented to you to make the decision as to whether or not there was helpfulness. And you can look at whether or not there's a conviction and see if maybe the witness testified at the sentencing hearing. So there's a lot of evidence that's before you based solely upon the records that are presented to you that you can use to make the determination as to whether or not you can certify.
And so when you look at helpfulness as per the regulations, what's important to understand, and this is what trips up a lot of people, the statute says they have to be helpful in the investigation or prosecution, but the legislative history made it clear that detection was enough, if somebody's helpful in detection. And the regulations have confirmed that judges who sign certifications are signing certifications based on, because judges don't investigate or prosecute. Judges detect and make findings. Judges also might be involved in a conviction or sentencing. So it's important to understand that a judge could detect because somebody came in and filed a temporary protection order, and then they showed up for the protection order hearing and they made sure the perpetrator got served. And so that's enough helpfulness without ever having a criminal case. And that's why when we wrote the statute, and I was actually involved in drafting the new visa, we chose the term criminal activity as opposed to crime. Because it didn't have to be a criminal case for somebody to come forward and be helpful on the criminal activity. And again, that's one of the reasons we made judges sign certifications. And so the other thing that's interesting about judicial certifications is from a judicial ethical perspective, most judges sign certifications after they make a ruling, and what happens is victim has to be helpful to get certification, and then after they get certification, the victim has an ongoing responsibility to provide assistance or cooperation that is reasonably requested, and here the request has to come from law enforcement or prosecutors. But there's an exception to this in which a victim could decide, in a lot of domestic violence or sexual assault cases, there's ongoing threats to the victim, and it may be too dangerous for her to cooperate, in which case she can show to the Department of Homeland Security that she didn't unreasonably, or he didn't unreasonably refuse to cooperate. Oops. So we're going to do another poll now?
Yeah, we're going to do another poll. So I guess the question here is, why would victims seek U visa certification from state courts? Let's see your answers.
So you have 4 choices. And if you could vote, we have some votes coming in.
You have a very smart group here.
Okay?
Oh, 100% all of the above. And that's exactly right, because, you know, sometimes the victim comes into contact only with the judicial system. If they come in for an order of protection, or if they're coming in on a family case, they may not see any other part of the system other than a judge. When they call the police, they may not have been able to access the police because they might not have had an interpreter present, or the interpreter might have been the police officer, or in some horrible cases, they have a family member interpret. And the judge observes the victim attendance and participation in the criminal cases. The judge is there all the time. So you're absolutely correct. It's all of the above. And when you're doing the certification, you have to understand you're not saying, oh, make this person a U.S. citizen. You're just saying basically three things: that the applicant is a victim of qualifying activity, that they have knowledge of that, and that they were or likely to be helpful, or they are being helpful in the detection, investigation, prosecution, certification, or sentencing. So that's basically what you're doing. With a T visa, you are saying that the victim complied with reasonable request for assistance from law enforcement or prosecutors unless the exemption applies. And the exemption is if they're under 18 or if there's a physical or psychological trauma. So you don't, you know, that's all you're saying, and DHS will go through it and look at it with independent eyes when they actually get to reviewing it. The helpfulness requirement is met when a victim reports a crime. And even if I say, you know, report a crime, I say my husband beat me and then he disappears, there's nothing else that has to be done. That's enough for helpfulness. Even if they catch my husband, say later, and they find him with a kilo of cocaine in the car, so they decide to prosecute him for that instead of the crime that he committed against me, that's okay. That they don't need to be prosecuted for the crime that they're seeking immigration relief for. So it doesn't have to result in a guilty plea or conviction, and there doesn't have to be a criminal prosecution for there to be the helpfulness requirement met. So many times people set that bar too high, and that you really don't have to. Leslie?
Okay, so, and what's also important, sometimes it's important for people to know, and I know this is a little hard to read, but we have this in your materials. It's a timeline, and it shows that at multiple points throughout the process of what can be 15 or 20 years now in getting a U visa, victims are required to show that they've continued to cooperate, they didn't unreasonably refuse to cooperate, and the Department of Homeland Security will run their fingerprints and take that and check their background. So this is not a path that somebody with a long criminal history is going to be likely to get through, and the Department of Homeland Security has the discretion to waive criminal history at each of these points in time.
This is the certification form that will be presented to you, and you can amend it in any way that you want. So what I do is I always strike out that bottom sentence that's stricken on this slide, that I certify that if they unreasonably refuse to assist in the investigation, then I will notify them. I'm not going to notify them. I'm not going to know, for the most part, if they continue to assist or not. So I just strike this. This certifies that I believe this applicant was a victim of a crime, and it gives evidence of that to DHS. DHS is the one who decides whether or not immigration relief is granted. But if the case, I've had attorneys argue with me about amending this, but you can amend it. Leslie, I believe you checked with them, and they said that's fine. But you can amend it, and you should amend it to be something that you're comfortable signing as a certifier.
And that's exactly right. I've done trainings with the Department of Homeland Security experts on the U visa, and they confirm that the judges can amend the form. We tried to convince them actually to write the form in a different way that would be better for judges, but they don't do it. They didn't change it. And so judges can't they don't certify based on investigation or prosecution, investigation of the facts, because they don't investigate. So they'll need to say, based on my issuance of a protection order, or based on my issuance finding a probable cause, and then they can cross out that last line, which is, again, a judicial ethical issue.
That's right. Just write it in and say, based upon the review of the reports attached. So it's easy to amend it.
And we have a brand new tool for you that you can provide to judges who you're seeking certification from, and it goes through all this in detail, and it's fully inclusive of the T visa and U visa, and it has all the citations to the DHS regulations and preambles in it. Over to you, Judge Breslow.
Thank you. So special immigrant juvenile status is a determination. Eligibility for the status is determined at the state court level. So that's why I and DC Superior Court am making these determinations that a kid is eligible. And it's a form of relief for unmarried children who cannot be reunified with one or both children because of abuse or neglect or abandonment. The both one or both is really important language. It does not have to. You don't have to have a child who's been abused or neglected by both children. It can be abused or neglected child because of the conduct of one parent. So the way some of these cases come to me, most of them, is custody actions filed often by a parent saying, I want legal custody of my child because my child has been abused or neglected by the other parent. Now, sometimes it's a third-party custody case, and it's a aunt, uncle, cousin, whatever, adult sibling seeking custody. But it can be one parent against another, and that is not uncommon. The important thing that I think you're going to want to stress to judges when you seek to have a judge make a special immigrant juvenile decision is that the judge is not, N-O-T, not making an immigration decision. State court judges, myself included, when I was very new to this calendar, we don't feel comfortable making immigration decisions. It's not what we're trained to do, and in fact, we're not allowed to do it. And it's important for litigants, for attorneys, to stress to judges, you're not making an immigration decision, judge. We're just asking you to make the kind of decision you make every day. Should this person have custody of this child? Is this child an abused or neglected or abandoned child? And really, judges in family court in D.C. make those decisions all the time. It's important to look to state law, your specific state law, and make sure that you can get the child to meet the definition of abuse, neglect, or abandonment. We've got a pretty expansive definition. The D.C. Code 162301 talks about the different types of neglect, and they consider physical or emotional abuse a type of neglect. We always look to the status of the child, not the conduct of the parent. The child needs to be found to have been neglected or abused. It can be sexual abuse, it can be emotional abuse, it can be that a parent failed to protect the child. And I think one of the most common, abandonment is probably the most common if the child has been abandoned by one parent. That would qualify the child to be classified as a abused or neglected child. But parental incapacity is also really common, and that can be incapacity of the parent because the parent is in a hospital, or the parent is in jail, or the parent is physically or mentally ill and incapable of providing parental care to the child. So it's a pretty expansive view of neglect. And again, as I said, you only need that finding with respect to one parent. So when you're looking to a state court, to the state court finding the judge needs to make, there's a couple of different findings that the judge is required to make. You know, the first is pretty obvious. The judge is sitting in a court that has jurisdiction to make custody or placement decisions about a child. As I said, the plaintiff can be the non-offending parent. It can be a third party. And the court is also going to have to make a finding that it's not in the child's best interest to return to the home country, and also, it's a separate finding, that the reunification with the offending parent or parents is not viable because of abuse or neglect. So there's a lot of different findings that the judge needs to make. I think we've given you a copy of a number of different SIJS cases from the DC Court of Appeals. And if you read through some of those cases, you'll see that our Court of Appeals has asked us to take a very expansive view of eligibility for kids for SIJS status. But I wanted to ask Leslie a question, which is why I typically do not see in my SIJS cases a request for child support from the neglecting parent. Do you have any thoughts about that, Leslie?
Yeah, I think it's really interesting because under immigration law, can you hear me? Yeah, under immigration law,
yep.
A child support order can be a super useful thing for someone who's ultimately going to have a path to legal permanent residency or citizenship. And what I mean by that is, so if you're working with someone who, because of one of these crime victim remedies, you know, there are different points in time where, in different kinds of immigration cases, where somebody might have to prove that they're of good moral character. And one of the ways you prove that you're of good moral character is you prove either that you're supporting your child, you're paying child support, or you can show, if you're the custodial parents, that you've actually gotten a child support order. So child support orders, particularly ones ordered through the court, because again, having the record that somebody has actually paid child support is something that if the non-custodial parent or the abusive parent at some point has a path to legal permanent residency or some kind of status, having paid child support actually can be a benefit. So I always visited getting child support in the cases where I was working with immigrant victims, because it is a win-win for both sides when you really think about it. And certainly for the child.
I'm going to actually start bringing that up in my SIJS cases. I just wanted to point out that the SIJS eligibility question can come up in a lot of different places in DC Family Court. So it can be in our dependency calendar is called the neglect calendar. It can be on the neglect calendar. It can be on the delinquency calendar. It can be through our domestic violence civil protection order calendar. It can be custody or divorce cases in our domestic relations branch, paternity and support cases, or adoption cases. It really can be a lot of different calendars. And the Department of Human Services talks about juvenile courts as like a very broad definition of types of courts. So the hearing, what does the special immigrant juvenile hearing look like? It looks kind of like a custody case. I bring the parties in. In my cases, the person seeking custody and seeking special immigrant juvenile status for a child is often represented, often by KIND or neighborhood legal services or IUTA or any of our other legal service agencies here in DC. I'm going to hold an evidentiary hearing. It's not super long. It's maybe an hour or less. Usually there's two witnesses, the person seeking custody and then the child often testifies. We have a very good interpreter's office in DC, and we always have the court interpreter present to interpret for family members or children that need interpretation. And then at the end of the proceeding, I make two decisions. Number one, I make a custody decision. Should I grant custody to this person? Because by granting custody, I'm placing a child, and that's required for the SIJS determination. But if it were, say, a delinquency case, maybe I would be placing the child in the care of the state. So I make a placement decision, and then I make a decision about whether or not the child meets the SIJS requirements. I'm always going to look at best interest factors under DC law, and Title 16, Section 914 has actually, this is a good summary, but there's actually 17 factors. It's very tedious. You have to go through all of them. But this is a good summary of them. And the bottom line is, is this child safe? Are his needs being met? Is he getting the mental and physical care that he needs? What does the child want if the child is, not a very, very young child? And how fit is the parent? So those are sort of the more important things that we're going to need to look at. But ultimately, I'm just going to make a custody decision. And then if I have gotten the right evidence during my hearing to make my custody decision, I should have enough information to decide if this child is eligible for special immigrant juvenile status.
Thank you, Judge Breslow. So what's interesting here, just as Judge Breslow said, this is really about child's best interests. And on this factor, when you talk about whether it's in the child's best interest to return to the home country, one of the things that is important to think about, and I think why the approach Judge Breslow is talking about makes so much sense, and it's certainly the approach when I've done trainings with the Department of Homeland Security staff on this, that they agree with, which is the first thing you want to do is look at anybody who could be a custodian of this child. So you want to look, let's take an example where dad a teenage daughter in Honduras in the home of his mother, the child's grandmother. So you have as potential, and mom's now in D.C. So you have mom in D.C., you have dad in Honduras and grandma in Honduras, and you don't have any other relatives who's necessarily been involved in the child's care and custody. Well, you're going to, using the D.C. best interest factors, eliminate dad and grandmother because dad abused the child and grandma let it happen. And if mom meets the other analysis that Judge Breslow was talking about, you're going to be able to easily make a finding that it's not best interest of the child to be in Honduras because there is nobody that can care for them, that it would be in the best interest for them to be in their care. In addition, you might have other factors going on in Honduras that you might want to talk about in particular cases. But first and foremost, you're going to get to this factor through custody first, or the placement and why that's in the child's best interest. And then once the court has found that this is the person that it's in their best interest to be with for custody purposes, it's easier to get to this reunification not being viable. And what this means under family law is if the judge, Judge Breslow, a contested custody hearing and decided that mom's going to have sole custody and dad's going to have supervised visitation. The fact that dad continues to see the child for supervised visitation, the judge can still say reunification is not viable. I'm not imagining at this point in time in the near future or maybe ever that I'm going to shift permanent custody to dad instead of mom. And that's the way to think about it. That's why judges can, once they get, as Judge said, they're addressing custody, these other issues often can flow directly from that.
Okay, so we have another scenario. So remember the Clara and Eduardo scenario from before, in which of the following cases could the court not issue an SIJS finding for Lupe, the young daughter, as part of the court's order? So let's see if we can get the polls up. Let's see what y'all think.
Anybody voting?
Anybody?
We have, okay.
Once again, it looks like we got some smart people here.
Judge Collins, you want to talk about it?
So what you have to look at is what exactly are you doing? When you're making an SIJS order, you have to be a court that has jurisdiction to place the child. And so if you have an order of protection where you're giving her custody, then you're placing the child. If it's a custody case, you're clearly placing the child. If it's a child welfare case, then you're making a decision about where the child will be, then you're doing it. The only case that you won't be doing that is the criminal prosecution of Eduardo, because you're not making any kind of decision regarding where Lupe will be staying in that criminal case.
So, I mostly covered this already, but the best practice for the court, and you want to help the judge, litigants and lawyers need to help judges get to best practice. You want to get the judge to make very detailed findings. I always like to, and I tell my law clerk this because she helps me with the findings, like tell the story of what happened to this family. And, you know, give all the details that you were able to get during testimony. In what way is this child abused? You know, make sure it fits into the definition of your state court definition of abuse. Make findings specific to each parent. Talk about any evidence you have about trauma on the child, and then just connect those dots. Tell the story. Explain why, you know, these facts add up to a legal conclusion that the child is abused or neglected, that the child needs protection, and why it's not in the child's best interest to be with one particular parent versus another, and citing state law, state cases, just making everything as specific as possible is really important. And, you know, I don't really know what happens to most of my SIJS cases after I determine that someone is or is not eligible for SIJS status. I guess if I find it, well, I do know that if I find that the child is not eligible, I know what happens because nothing happens. But if I find that avenue for immigration relief is now cut off to that child. But if I make a finding that a child is SIJS eligible, then the child's lawyer or the lawyer for the custodian of the child, their next step is to apply for SIJS status and to take it to immigration court and see what happens. And the immigration court is going to want as much information as possible. So the more detailed the judge's findings can be, the better.
Absolutely, and I think that's a really because a lot of lawyers sometimes might be reticent to ask judges for more detailed findings, but how does, from a judicial perspective, isn't that something you guys do kind of, you're used to doing? It's not an unusual request for you, I assume.
That's correct.
We do. Go ahead.
Yeah, and what we do in my SIJS cases is I ask the lawyers to submit proposed findings in advance of the hearing so that I have a sort of a template to work with. But what I found is that a lot of times I just got a lot of sort of rambling stuff that wasn't organized the way I wanted it. So over time, my law clerk and I came up with some templates that we like a lot, and we send the templates to the lawyers in advance and have them use those templates to send to us, and then I have the sample, then I listen to the evidence, and then I tinker with, you know, the facts and the specifics. But I try and keep things in order of the templates so that I know where to find each finding and so that it's organized.
Yeah, and that's a great way to handle it. Just make sure that your attorneys aren't giving you orders or form orders that don't seem to have the factual findings in it. So it's important that you make sure that they have the facts that the reviewing immigration authorities need to see. We're going to briefly talk about VAWA confidentiality. VAWA confidentiality was designed to prevent abusers from and crime perpetrators from using the immigration system as a tool of power and control over the victims or as a means of tracking and stalking their victims. So it's an important tool that we have. It really does help promote access to justice and fair outcomes in our courts because victims can feel confident to know that the courts aren't actually going to help betray them and give information that's very sensitive and potentially very dangerous to abusers. Perpetrators often attempt to use state court discovery to obtain this information because they want it, and sometimes state court judges don't know or state court lawyers don't know what the rules are about VAWA confidentiality. So perpetrators will try to get that because they want to know where their victim is. Maybe they want to have other information about them, who they talked to, things like that. And so they try to get this information all the time. VAWA confidentiality also has provisions in it that protect immigrants from enforcement in certain locations, including courthouses. So it's important to know where those locations are, because that way, if you're arranging a turnover of a child to another parent, you can make sure that you do that turnover at a prohibited enforcement location so that your immigrant victim is safe. Leslie?
Thank you. So this is an overview of VAWA confidentiality. Again, we have links to lots of materials on this and webinars that we can provide you. But basically, the way it works is that perpetrators are prohibited. The federal government, DHS, Department of Homeland Security, Department of Justice, Department of State, are prohibited from relying on perpetrator-provided information to harm victims or interfere with their cases. That's kind of one of the fundamental tenets of VAWA confidentiality. There are also protected locations, including courthouses and all kinds of victim services programs that prohibit enforcement against victims at that location. And there's also non-disclosure provisions, and that's where we're going to really drill down a little bit here to talk about the provisions that protect against discovery of the existence, the contents of, or anything about a victim's immigration case. Is that mine? Yeah, so that it basically covers all of those things, and any decision taken in an immigration case is not disclosable.
So the general rule is that discovery is prohibited. It just is. And so the case files are not discoverable in family law cases. In criminal cases, only the certifying document is discoverable. So that's all. The prosecutors don't have the immigration file, so it's not in their custody of control. It's only the certifying document that can be discovered. In civil cases, it's not discoverable except as it may be needed to prove damages to a specific individual. And I think, Leslie, you've got a case that you're going to talk about that particular aspect of it. And a judge can review it and redact. If it's one of those few instances where there's maybe some parts of it that are discoverable, then the judge can redact and make sure that the rest of the file is not turned over, because the general rule is do not turn it over. Leslie?
Thank you, Judge Collins. And so what's important to understand is that the case that Judge Collins was talking about is Koch, EEOC versus the Koch in Mississippi. And it was a Fifth Circuit case, and basically they confirmed VAWA confidentiality even in a civil context. And there it was a case of multiple sexual assaults against multiple victims. And what they said is that, the certs themselves could be potentially discoverable, but not connected to any individual. Now, when you're talking about a family court case or a criminal court case, you don't have multiple victims. So the purpose of VAWA confidentiality, as you can see from these cases, and we have lots of more, these are just examples of some of the case law around the country, is courts have continuously recognized, state courts, federal courts, that there is a prohibition on disclosure of these confidential materials, particularly to any accused batterer. And so they are not discoverable. And that's even true when the victim gets immigration relief, ultimately not through the Violence Against Women Act protected case. The VAWA protections apply forever to that case, whether or not that's the way the victim ultimately received legal immigration status. So you can have somebody who receives it through a case the perpetrator filed or through a work permit in some other way, but it continuously applies to these cases. And this case has some really good language about why discovery in family court is barred by VAWA confidentiality, and how allowing discovery in family court of the immigration case would undermine the whole purpose of what the federal confidentiality statute was designed to achieve. So now the last part of this webinar, we're going to give you kind of overviews of some specific topics and ways that immigration law issues arise and how to address them when they come up in all kinds of family court proceedings. So what happens is we know some of the social science data is really clear that when immigrant victims can seek protection orders, get immigration relief, and other things, that those protections, like we're talking about, that are offered to the mother really do work to decrease the co-occurrence of child abuse in these families, decrease the likelihood of child snatching or, in these families as well. Judge Collins?
First question we always ask in any case when there's an objection to evidence, is this evidence even relevant to what the issues are? So when you're determining a custodial issue, is immigration status relevant? Well, it certainly isn't relevant to who's a better caretaker. It's not relevant to parenting skills or the best interests of the child. It could possibly be relevant to, as Leslie talked to before about the threats of violence and the cut telephone cord. It could be relevant if you're doing immigration to show that you're a victim of immigration abuse, so that your partner or your spouse won't turn in your immigration papers, they've taken your passport, and that can be relevant to an issue of immigration abuse, which we know shows other issues there, or that the other partner is saying that they're going to turn them in for deportation. So it can be relevant to show the history of violence and abuse, but it certainly isn't relevant to any best care or best interests of the child determination. There's some really interesting myths out there about immigration. We often have in our court cases where the abuser will say, well, you can't give custody to her because she's going to be deported, or she's going to flee the United States with my child. And there's some really interesting actual studies that have been done to show that the immigrant parent is much less likely to flee. For one thing, they don't have as easy access to fleeing the country, but the lawful permanent resident does have access to leave the country. So when they are dual nationals and they can travel freely to and from the United States and there have been threats of kidnapping, your U.S. citizens and lawful permanent residents are the ones who are most likely to flee with the children, not the immigrant parent. So also they say, well, she can't get the child because she can't work. But we know that the abused immigrant have a path to immigration relief and to get some benefits. And that's important to know. And Leslie has a lot of great information about benefits that are available to people. And you don't have to be a citizen to file for immigration's relief for children. So you don't have to give custody to the lawful permanent residents or citizens because the immigrant parent can't file papers, because that's just not true. So it's important to listen to what's being said in court and then to find out what the facts really are. And these myths should not be used to make a determination of custody. Leslie?
And what's really important is that sometimes parties are going to tell the court that immigration law says something that it doesn't say. And this other one is a great example because there are actually reported cases where the non-custodial parent will come in and say, I'm a citizen, you have to give me custody or I can't file papers for my children. It's a total lie. In immigration law, they can file papers because they're the citizen parent. It has nothing to do with custody. So, and this is just the other thing that's important is sometimes courts might wonder, and you might have a case, you might wonder, well, is it true? Like if the victim is, if the custodial parent, the person seeking custody of the child, or the non-abusive parent is undocumented, are they likely to be removed? And the answer is no. This is 2013 and 2017 data, and what you can basically see here is that where parents who don't have criminal convictions or don't have an open immigration case before an immigration judge right now or an outstanding order of removal, they're not likely to be removed as a practical matter, even if you're just looking at the DHS data. And so the confidentiality and sensitive location information is really important. This is the full list. So on the left-hand side, you have all the places that are protected by VAWA confidentiality. And on the right-hand side, you have all the places where ICE, immigration enforcement, and can't happen by anybody because they're protected locations from immigration enforcement. So, you know, exchanging children at a church, for example, might be a better choice than exchanging children in a police department because the church is on this list of places that ICE can't do immigration enforcement. So that can be very helpful to you when you think about custody and exchange and what's safe. The other thing that's important is that there's great case law, and this is one example of a case. This was a child welfare case in which there was a termination of parental rights. And what we found in this case is they basically terminated a mother's parental rights because she was in detention and didn't get notice of the proceeding, and then was removed and wasn't able to do a reunification plan in time. Bottom line is the court reversed the lower court's decision unanimously and basically said that the constitutional right to custody absent fitness applies to, absent unfitness applies to undocumented parents, people in deportation removal proceedings, people in detention, people who have been deported, and that being an immigrant or undocumented isn't a sign of unfitness, and that there's an overriding presumption that the parent-child relationship is constitutionally protected, and that courts shouldn't be entertaining a comparison of countries to decide, well, of course, which is what happened in this case, these U.S.-born children, although they don't speak English because they grew up speaking Quiche and Spanish, are going to be better off in an adopted parent's house where they speak English in the U.S. than at home with their mother in Guatemala. And so there's just really good language that you can look at on this point. But one of the good things that came out of that horrible case, other than the victim getting her kids back, which she was reunited, is they created a detained parents directive that mandates that the Department of Homeland Security bring detained parents to court for any kind of a proceeding involving their children. And so we have a brochure in the materials that tells you how to make this work. If you have a case with a problem, we can give you the number of somebody at the Department of Homeland Security who's the supervisor person responsible for making this happen. And so you shouldn't, if you're working on a case where this comes up, there is a remedy to this.
And I just wanted, Judge Brooks, I just wanted to jump in on the detained parents directive, that it is possible in D.C. Superior Court to bring a parent into the D.C. Superior Court when they are involved in a child welfare case. I've only had it happen once, and it was complicated, but we did make it happen. We weren't, the U.S. Marshals were involved in transporting this guy, and it was very complicated, but it can be done.
Absolutely can be done, and it's supposed to be done. So I'm glad that it was able to happen in this case. So now the next topic I want to go into is to just highlight some key issues that come up in protection order cases. First of all, the definition of domestic violence under immigration law is battering or extreme cruelty. Every D.C. protection order that's issued is issued based on an interfamily offense. All interfamily offenses in D.C. qualify. There isn't an interfamily offense in D.C. that wouldn't also be battering or extreme cruelty under immigration law. Because the immigration law definition, as you saw earlier when Judge Collins was talking about it, includes forms of emotional abuse that may not be covered under the state protection orders. So what's important to know in protection is that issuance of a protection order has no effect on the immigration status of anybody. A conviction or a finding in a state court order of any kind that somebody violated the protective provisions of the order. And that means if the violation is they continue to bring the child they violated the order in a way that is about stopping the abuse more directly, that would be a deportable offense. And so it's important to understand that that violation of a protection order, and this is the exact language of the statute, the protective provisions of the protection order could be a deportable offense. And as a result, Judge Collins, what might be good for courts to do, or or family lawyers to ask judges to do in protection order cases?
Well, we do issue warnings about collateral consequences, particularly collateral consequences that are this extreme. So you should do a Padilla type advisal. So you should tell the parties that there could be consequences for immigration relief if you violate an order of protection. It's really important too. And when parties come in and they both want an order of protection, and one party might not have represented and the other one might be, and they both say, well, we're going to issue orders of protections against both parties, and the consequences of getting an order of protection are substantial, and violation of that order could mean a denial of immigration. So it's very important that the court makes sure that the parties understand that and that the attorneys understand that. And if you have somebody unrepresented, you may want to make sure that you do an extra special job of explaining it so that they don't enter into an order of protection unknowingly, setting themselves up for a violation order which could get them deported from the country.
What kind of creative protection order remedies might you include in a protection order that could help an immigrant victim?
Well, you can always have like if you have an immigrant victim who's worried about where their papers might be, you can always order the papers to be turned over and to order any documents that the victim might need to be turned over to the person who needs them. You can make sure that you can stop this immigration abuse by issuing orders that say that this abuse cannot occur, and so that you cannot withdraw. Say somebody has filed a petition on behalf of their spouse, you can order that they don't withdraw that petition for immigration. You can protect victims that are still living with their abusers, because we do have people who still want to live together, they just want to be safe. So you can issue orders that protect them but still allow them to live together, even though that's very difficult for police to enforce.
Judge Collins, though, but what's interesting on that, and this is a very important thing for immigrant victims, because what we know from both our experience working in the field and social science data is that many VAWA self-petitioners and U visa victims continue to live with in domestic violence cases, continue to live with their abusers until they get work authorization, so that they can actually, survive on their own.
Yeah, they often have no other way to support themselves. They have no place to live. So it's important that you don't just say to people, if you're going to live together, I'm not going to issue this order of protection. And you can order things like spousal support, child support. You can order the spouse to have health insurance that protects the immigrant and the child. I mean, you can do those kind of orders to protect somebody so that they can get their financial footing underneath themselves, and maybe then can make the steps they need to get into a secure location.
So this is an order, this gives you an example. This is an order actually that was crafted by a DC judge in the 1980s, and that has been used across the country since then. And it was designed to try to help stop this immigration-related abuse and other kinds of coercive control that a perpetrator might try to exert over a victim. So it's a good example of a case, and again, we have whole chapters and materials we can provide you on other examples of this. So the next topic we're going to talk about has to do with child support. We have many, many children, immigrant children, and citizen children live in families with mixed immigration status. And you get all kinds of interesting things happening, and I'm sure Judge Bressel, you see some of these, in child support court where, and as I said earlier, the payment of child support through the court helps provide evidence to the paying parent if they, for a cancellation of removal case they might qualify for naturalization, for other forms of immigration relief. And for the custodial parent, it can also help them prove that they're, if they're not a victim and they're applying for a form of immigration relief and they need to show that they're not going to be a public charge, then getting child support, even if it's not collected, could, an order, even though it's not collected, could be a way to show that they've got a plan for not being a public charge. It's good evidence of that. The other thing I just want to mention about public charge is VAWA, any victim who goes through VAWA self-petitioning, U visa, T visa, SIJS, their asylees, refugees are exempt from public charge. And that it's important because immigrant victims, it's hard, some victims will have a more difficult path for subsidized health care. Keeping people on insurance, children particularly on the insurance, it can be useful for that purpose. What we see, we've had people in places around the country where the perpetrator or the, usually I'm thinking a lot of domestic violence cases, or non-custodial parent will walk in and say, you can't order me to pay child support, Judge, because I'm not legally authorized to work. Judges, is that a valid defense?
No. Definitely not a valid defense.
No,
Exactly.
They can work, and they have to pay child support.
Right. And if they're working and or they have resources coming in from however they're supporting themselves, they can be ordered to pay part of those funds for child support, correct?
Yes,
Correct.
absolutely.
Yeah.
We
And
do it
so
all the time.
That's the exactly. And what's interesting is that a lot of times people will try to say, but if in fact they're working, they can be ordered to pay. Now, what's interesting is the typical kind of job search that a judge may order a non-custodial parent to do in a child support case, you can't order somebody who doesn't have legal work authorization to search for a job. That would be a violation of the 1996 IRCA laws, immigration laws. But that doesn't mean they can avoid child support, and in fact, they can be, and the other piece is that a conviction for failure to pay child support could be a deportable offense for theft. So that's another thing that could happen. There's also been cases where sometimes the court will order wage withholding, and the employer will not withhold the wages. Largely, maybe it's a family business or something like that. There's been great case law across the country holding the employers accountable for paying that child support if they ignore the court orders. So that's another issue that comes with child support cases. So the real trick, I think, and I think this is where we're going to need to start winding down because we're getting close to the end of our time today, is what kinds of things have you done to impute income or to help prove income, or as judges, what have you seen about ways that people have been effective in proving kind of income of people who are working in the underground economy, for cash under the table? How have you handled that in your cases?
You can always look at their assets. Go ahead, Judge Bressel.
Oh, thanks. It's really difficult. But the reality is even someone who tells you that he or she is not working, they're probably doing something and they're supporting themselves in some way. And so just making sure that whatever examination of them when they're a witness is happening is really, really thorough, and finding out, how are they meeting their own basic needs, and how can we divert a portion of that to meet the child's basic needs. but it's difficult. There's no question.
I haven't bring their tax returns and show me, you know, because they have to file tax returns. I'm bringing that. I have them tell me about what they're living in, what are they driving, you know, how are they paying their rent, how are they paying their cable, you know, how are they paying all these bills, and they are often working on the side. So you can attribute a certain amount of income just about because they can work and they are working. It's a little harder when your unemployment is really hard or really high. But in the past, when unemployment has been really low, it was easier to do that.
So I'm going to skip forward a couple of slides and just pick up on something Judge Collins just said. Oops, it's stuck. Is it going back? Oops. Yeah. One of the things that is also important to know is that some of the people you work with will have signed they will have been sponsored for immigration status by their spouse, and that spouse will be signing an affidavit of support. And that affidavit of support both can be enforced in a divorce case in D.C. and should be. Second of all, and that's a way to get, it's independent of alimony because it's a contract, but it's like alimony in that you can get funds for the spouse, not just for the child. But what's really great about it, and what judges we train love about it, when the sponsoring spouse filed the affidavit of support, he was trying to brag to the federal government about all the money he had, how much money he had, so that his family members could emigrate. So there's usually a big difference between how much money he had when he was bragging to the government so he could bring his family in terms of how much he says he earns, and when he walks in trying to be poor in child support court to avoid, or trying to avoid paying child support or spousal support. So it's really very potent, powerful, and that this is the evidence that they have to file in the affidavit of support case, so it's good to know it's there. The last point I'm going to make is just to talk just for a second about divorce. And all I'm going to say is divorce is not benign when it comes to immigrant families. It can trigger when you have to file a VAWA self-petition. It can end family members' dependent visas, and in asylum cases, it can cut asylees off from lawful permanent residence. So we have a divorce bench card in your materials. We can talk to you about that. We've also seen cases where perpetrators in particular will walk in and try to get an annulment of a 10-year marriage with 3 kids instead of a divorce. And then if they succeed, they'll turn around and try to get their spouse charged with federal marriage fraud. So it is not benign, and it shouldn't be an annulment unless it really is an annulment, and certainly not in long marriages. So I'm going to wrap this, unfortunately now we are out of time, but I want to end with information. We appreciate you attending today. We have information available for you that we will email you with the PowerPoint, hopefully a copy of the recording, and a whole bunch of training materials that are available to assist you. You can also, when you're working on cases, call us for technical assistance as lawyers or victim advocates. We also provide judge-to-judge technical assistance. If you're a judge or a court staff and you want it, or you know a judge, or you're working with a judge who wants to talk to another judge about how how they've addressed immigration issues that have come up in their cases. So really, I want to thank you for your time and attention, and I want to thank the DC office for victims, crime victims and grants for their sponsorship of this event and helping us set it up. And I want to thank Vern for being so great in running this webinar, and Cheryl for all your hard work. And thank you for attending, and please don't hesitate to give us a call if you have any questions. And thank the judges for all of their time in helping prepare this.
My pleasure.
Thank you all.
I learned a lot too.
Thank you. Me too.